case briefs, and so much more. LS Data's got what you're looking for.
In a decisive turn of events in 1990, the United States Court of Appeals for the District of Columbia Circuit oversaw a contentious environmental dispute. Central to the argument was the United States Environmental Protection Agency's EPA interpretation of Section 115 of the Clean Air Act, a topic that bore heavy on the case referred to as Her Majesty the Queen in Right of Ontario. This is United States Environmental Protection Agency. Simmering at the heart of the dispute were petitioners from Ontario and New York. They locked horns with the EPA, advocating for the implementation of Section 115 of the Clean Air Act. Comparatively, the EPA held a different interpretation, arguing that the obligation to initiate such procedures was only necessary once specific sources of pollutants in the United States were identified as the actual offenders causing harm in Canada. The court sided with the EPA, ruling that such concrete identification was currently beyond the agency's capabilities. Before this development, the case had seen its fair share of legal battles, as reflected in the district court's decision. However, in a contrary move, the Court of Appeals reversed this judgment. It argued that Administrator Kossel's findings were rules under Section 551(4) of the Administrative Procedure Act, and thus could not be enacted without prior notice and a chance for public comment. Despite the twists and turns, the court ultimately decided to apply the Chevron deference standard. The court found the EPA's approach permissible. It agreed that a clear correlation between pollutants and the endangerment of certain areas needed to be established before implementing the specific abatement procedures outlined in Section 115. It also held that the EPA's delay in processing the petitions was justified given the scientific and technical uncertainties of the situation. Similar patients couldn't be granted regarding the clay letters. As such, they were deemed as final agency action and ripe for review. The court upheld the belief that Section 115 provided a unitary or divisible proceeding, thereby denying the petitions for review. The court concluded that, based on the evidence, the EPA had not taken final action on the petitioners' rulemaking requests, which would signal the initiation of Section 115's pollution abatement procedures. Thus, in an environmental case that kept many on tenterhooks, the scales tipped in favor of the EPA. The court concluded that their handling of the issue and the resultant delay was neither arbitrary nor capricious, thereby informing the eventual dismissal of the petitions for review.
Case briefs, and so much more. LS Data's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.